Welcome back to Learn SKN, and today we have a continuation from the previous MOB video that we did, the previous management of business video that we did. We started looking at legal structures in the economy, and we started by looking at the sole proprietor or the sole trader, and we outlined some of the negatives, the positives of that legal entity. We also outlined some of the advantages, disadvantages, some of the features of the sole trader or the sole proprietorship. We also gave some examples. But what we're going to do today is we're going to jump right back in, and we're going to pick up right at partnership, because partnership and sole trader normally go comparison wise, hand in hand. And so we're going to pick up right there from the partnership. Now, the step up from a sole trader would be the partnership. A partnership is defined as a business where 2 to 20 people work together towards a common goal of making a profit. And of course, the main interest, the main reason why these private sector companies go into business is, of course, to make a profit, to maximize the profit, make a profit. And so a partnership is a business that has 2 to 20 owners, right? 2 to 20 persons who work together towards a common goal. So there's a limit right there, the upper limit to a partnership. So it's from between 2 and 20 persons who own and operate a business. Right? Or I shouldn't say operate, but they own the business. Some people are sleeping partners, they don't really engage in the day-to-day running of the business. The partners are often the main source of finance, even though the business can source funding from financial institutions. Like sole proprietorship, a partnership is not required to be registered. However, it is required to register its trading name, right? So I think I didn't mention that, but yeah, for some sole trader, they have to register a name if they want. You can register your name also. But the partnership, you have to register the name. The partnership is governed by the agreement that was drafted at its outset, known as a partnership deed. This is a legal document which amounts to a binding contract among partners. The document stipulates how profits or losses should be shared, the rights of each partner, rules for taking a new partner or dissolution of the partnership, and the capital to be contributed by each partner, among other things. So those are some of the highlights of the partnership deed. It tells you how the money should be shared, the profits, how the losses should be shared, the rights of each partner, and the capital to be contributed by each partner. Those are some of the few things that you find in a partnership deal, because not all partnerships are equal. You might have somebody who go, 60-40 or 50-50, 80-20, whatever the case. And so your partnership deal would outline how things are done, how profits are shared, how losses are shared, who put in how much income, how much capital. I put in 60% of the capital, you put in 40. So therefore, when profit come, I get the 60, you get 40. The intricate things like that are discussed, are outlined in the partnership deed. So it also tells you what roles partners might play, the rights of the partners. If you are a sleeping partner or if you are a day-to-day operating partner, things like that. And for sure, it's a legally binding agreement. It's a contract. And so you cannot really just stray far from it. You can't say, a lot of money rolling in, and so you're taking more because you feel like you're doing all the work and the other person ain't doing the work. No. It's what you agree on before you set out the partnership. So you have to abide by that. While preparing a partnership deed, it is advisable, it is not required by law, and so partnership do exist without one. That's confusion right there. You're looking for confusion. So if you're going into a partnership, make sure you have it written out in black and white. It's not required. You can be word of mouth, but when push comes to shove, you want to make sure you have the contract right there to show exactly what is what. You don't want anybody to come claiming what ain't belong to them. You put in most of the money and they want to get equal or more of the profits. You don't want that happening. So make sure if you start in a partnership, you put it in the farm, you get the deed out of the way. Make sure you have a deed. In such a case, the partnership is governed by the Partnership Act of 1890 and 1907. So the Partnership Act stipulates, you see all these things now? We're talking about acts now. We're in MOB, the same POB, we're talking about acts now. So the Partnership Act of 1890 and 1907, the Partnership Act of 1890 stipulates that profits and losses should be shared equally. So they're saying, right, if you don't have a deed, if you don't make a contract with your partners, you will require to abide by the Partnership Act of 1890 and 1907. You have to go by that if you don't have it in black and white. So profits and losses should be shared equally. That might not be fair because one person might put in more than the other, one person might work more than the other, but because you ain't had the partnership deed, the person, the free rider, gonna get the same benefits as you. Each partner may take part in the management of the business. No partner should receive a salary for working in the business. No partner is entitled to any interest on his or her capital. While the Partnership Act of 1907 did not disturb the rules set down in the previous act, it added the new concept of a limited partnership. Okay, this act stipulates the following: a limited partnership shall not consist of more than 20 people and must consist of one or more people called general partners, who shall be liable for all debts and obligations of the firm, and one or more people to be called limited partners. A limited partner shall not, during the continuance of the partnership, either directly or indirectly draw out or receive any part of his contribution. So all those are outlined in the partnership agreement. In the Partnership Act. A limited partner shall not take part in the management of the partnership business and shall not have power to bind the firm, as in they can go and sign a contract on behalf of the firm. So what I'm saying here is that if you don't have a deed, right, you have to abide by these from the 1890 and 1907 Act. And they're saying, like, no, we said that a partnership is 2 to 20, between 2 and 20. Now what they're saying here is that the Act states that there should be general partners and there should be limited partners. Everybody can be on the same level. Everybody on the same level. You have the general, you have the limited. Remember in POB we said that in partnership, at least one of the partners would have unlimited liability. So this is where you see it now. You see it's more expanded now in MOB. So they're showing you that the Act of 1907 states that there should be general partners, right? There must consist of one or more people called general partners who shall be liable for all debts and obligations of the firm, and one or more people to be called limited partners. So some people not gonna lose all this stuff, just what they invested, and some, the general partners, are liable for the debts, and so they are the ones who would have unlimited liability. So in a partnership, so that will differentiate the partnership somewhat to the sole trader. Where sole trader you have limited liability, unlimited liability for everybody, for the owner, unlimited liability for the owner. In a partnership, you have both unlimited and limited, but it's outlined. You have to know who are the general partners and who are just the limited partners. And the limited partners, as it says, the reach, their power is limited. For one, they are limited as to how much they can lose if the company goes down. They are limited as to the managing of the business. They can't just come in and manage the business just like that. They are limited to that. And they are limited as to if they can do anything on behalf of the company, stand up for the firm, enter a contract for the firm, they are limited. That is up to the general partner, not the limited partner. So those are some things that the Act stipulates. So what are some features of the partnership? So again, unlimited liability on partners except for limited partner, as I said earlier, just now. 2 or more members, profit losses are shared, but the deed would say how it is shared, but in absence of a deed, it's 50-50. Few legal requirements, of course, you can have your contract signed, you have to register the name, things like that. No separation between business and partners. Again, we looked at that earlier when we looked at the sole proprietorship. There's no separation between the sole trader and the company, and the business. No separation between business and partners. So if you're suing, you're going to sue. If it's 20 of them, you're going to sue all 20. If it's 5, you're going to sue all 5. All 5 are liable, all 20 are liable. There's no separation between business and partners. Partnerships are prevalent in, but not limited to, accounting and law firms through the Caribbean. These include PricewaterhouseCoopers, Deloitte & Touche, George Walton Payne and Company, and Fitzwilliam Stone. Well, for those who are in these countries, you know who these, you know what these are. These are different companies in different parts of the Caribbean. So if I butchered any of those names, those who are in the countries, feel free to correct me. I'm not familiar with some of them, but most of them I am aware of. All right, so advantages of a partnership. Advantages. They are easy to form, as there are few or no legal requirements. Again, we said that earlier. There are few or no legal requirements. Of course, we outlined that if a license has to be obtained, you have to do that. Food handlers permit. If you want to sign a contract with the deed, all that is there, but for the most part, they're easy to form and there are few or no legal requirements. Each partner contributes to the capital of the business. So that's an advantage right there, because you have people to rely on to get some monies to help the business go, to help the business start and run. So each partner contributes. And even not only just the capital, but let's not put capital as money here, because it's both capital as in terms of money and human capital, because each partner would bring different skills, different expertise to the partnership, and that can help the partnership to be more versatile, more flexible. So not just money capital, but human capital also. Responsibilities may be shared among the partners, of course. No one person bearing all the stress, like in a sole trader. You can share responsibilities among your partners. Somebody in charge of accounting, somebody for marketing, somebody for production, etc., etc. It allows for division of labor, as partners may have specialized skills, as I stated earlier. So some partners have different skills, and as such, you can say, okay, you're in charge of that. I am in charge of this. So you don't have to be a jack of all trades as a sole trader, but you can have different people doing different things that they are good at. So that is how that goes. Then there's the privacy of affairs. It is not compulsory to publish the partnership's accounts. Similar to sole trader, we don't have to send out any information if you don't want. There are no annual general meetings, so you don't have to answer to any board of directors, not like that. You can keep them internal within the company. Disadvantages: partnership have unlimited liability except for the limited partner. So for whoever has the unlimited liability, that's a disadvantage right there. So everybody would not face this disadvantage, only those that have unlimited liability. So normally those general partners. Decision making may be tedious and slow. Again, you have to contend with different ideologies, different ways of thinking. So making a decision might be difficult, might be long, because everybody have their own say, their own point of view. Everybody put in the money, so everybody feel they have the right to say what they have to do. They have control over the business, and so you might have a long time trying to arrive at a decision if everybody isn't on board with the same mindset, the same wavelength. So it can be difficult. There might be conflict among partners. There is lack of continuity. That is, once a partner leaves, the partnership has to be dissolved. So once the partner leaves, it's no longer that legal structure, and so it has to be dissolved and then spun back up again with whoever remains if they choose to do so. The problem of limited liability may have led to the enactment of the Limited Liability Partnership Act of 2000. This act states that partnerships may be formed where all of its partners have limited liability. And so you have these things we call the LLC. So you have the limited liability companies, and so those are offspring or offshoot of the partnership. But in this one, you have all members, all partners having limited liability. And so that's a whole different legal structure again. So that's why you have the LLCs. And a lot of people form LLCs out there as opposed to straight up partnership. Right? So according to the Act, a limited liability partnership is a body corporate with legal personality separate from that of the members, which is formed by being incorporated under this Act. The members of the limited liability partnership have such liability to contribute to its assets in the event of its being wound up as it provided by the virtue of this Act. So what I'm saying is that, again, in this company, that's a new and different form of company. We have the somewhat structure of a partnership, except for the fact that most of them, all of them have limited liability, and in essence, the partnership has its own entity. Legally, it's its own thing, just like a company. Legally, it's its own thing. So if you're going to sue or whatever, if you're going to sign a contract, you're going to sign a contract with the partnership and not with the partners. So you're going to say it with the contract with the partnership, and not so the company name. You're going to say it with the company because it's an entity unto itself and not the partners. The partnership must submit the required documents to the registrar of companies who will regulate the partnership. Right? And so that's it for the partnership. And we're going to study it for now because we normally tie partnership and sole trader together because they normally compare both of them. Advantages, disadvantages. So we're going to stick there for now. Right? But you know what to do. If you want to see when we drop the next video in MOB for the different legal structures, you should, subscribe, of course, hit the bell so you know when the video drops, and like the video so that we can help spread the love. All right, so that's it for now. Thanks for watching. Thanks for listening.